All right, let's see what we got. Okay. Are we running? Yes, good. Excellent. All right. Let's see what we got. Emergency application for stay pending appeal. Okay. The applicant is Joe Newman per se. Well, I'm not sure that strictly speaking is true. Okay. So what's the easiest way to do this in terms of marking this up? Let's do track changes. Respondent is Juan Merchant. Is an LLC company wholly owned by Joseph Neerman and with separate counsel. Okay. Alvin Bragg is the district attorney. Intervenor, appellee below. Okay. List of all proceedings, State of New York Court of Appeals and the Supreme Court of the State of New York Appellate Division. Okay. So he was denied by the highest court of the state in September. All right. Supreme Court of State of New York Appellate Division, First Department, which is Manhattan. Okay. The New York Court of Appeals decision dismissing petitioner's appeal is published at 2024. This period should not be there. New York Lexus and reprinted appendix. Is published the correct vernacular for that? New York appellate decisions denying an injunction is published at 27 AD, reprinted at appellate B. Good Logic has been seeking an injunction of decision in order had been seeking an injunction of decision order I think I rewrite this. Say like sort of comment. Box page, cross-reference, hyperlink. Okay, do comment. Rephrase. Consider active voice. Okay. Injunction. Of a decision. Injunction of a decision. Is injunction of a decision the correct vernacular? Doesn't sound right. Good Logic LLC and Joseph Neerman filed their petition, an application for emergency injunctive relief with New York Court of Appeals, First Department, on April 12, 2024, in the matter of Good Logic versus Merchant. Okay. The appellate division denied preliminary injunction, dismissed the petition. Good Logic and Neerman filed a notice of appeal from the denial of injunction, dismissal of the petition on July 3rd. SSD 30. I don't know what that is. What is this? Doesn't look like the correct citation format. On September 12, 2024, New York Court of Appeals dismissed the appeal, which also sought the injunctive relief in question. Such that the dismissal presumably denied a stay. Yeah, stay sounds right. The gag order remains in effect. Appeals the verdict of guilt. What gag order? I know the answer to the question, but it's not established here. The petition, what the gag order is or relates to. This reference without a prior antecedent is confusing. Okay. Antecedent. Antecedent? How do you spell antecedent? Antecedent. How do you spell antecedent? A-N-T. Antecedent. There you go. Antecedent. Remains in effect as a criminal defendant, appeals the verdicts of guilt. This court has jurisdiction, okay, under USCS What is the extra S? U.S. Code. U.S. Code Service. No. Nope. No. Just USCS, please. Recommend U.S.C instead. And the Supreme Court, Rule 23. Pursuant to Rule 23, Good Logic and Neerman were parties to the action before the Court of Appeals, and relief now sought was first sought in the court below. Okay. Petitioners are required of a stay. What? Rephrase. President Trump is subject to the gag order. Okay. Petitioners are likely to succeed on the merits. The court misanalyzed and misinterpreted Supreme Court precedent while inventing a novel legal theory that inverts precedent. Supreme Court failed to comport with Nebraska. That's presumably a case name, so that should be in italics. If this is case name, it should be in italics. Petitioner's harm is irreparable. Grant of stay will not substantially injure other members of the proceeding. Issuance of the stay serves the public interest. The split in the circuits on the issue of gagging a criminal defendant so that his words may not hamper the criminal conduct should be resolved in favor of free speech. The First Amendment right of a candidate to speak and citizenry to hear that candidate is entitled to the strongest of First Amendment protections. Freedom of the press is entitled to the strongest of First Amendment protections. The fact that the gag order protected Judge Merchant from having to face legitimate media inquiries to President Trump conflicts. The fact that the gag order protected Judge Merchant from having to face legitimate media inquiries to President Trump about Judge Merchant conflicts of interest merits a stay. Like, rephrase, confusing. Okay. 303 Creative. Okay, Bantham Books. Nice. Buckley versus Vallejo. Nice. New York Times versus Sullivan. No. Consider Passam instead. Yep. Consider Passam instead. Yeah. Consider Hassan instead. Okay. Consider citing as u.s.c instead. Okay. All right. See, Honorable Sonia Sotomayor as Circuit Justice for the Second Circuit. Neerman and Good Logic are members of the New York press and have sought comment from President Trump about potential biases in his criminal trial, citing restrictions arising from the gag orders. Again, no antecedent. Without antecedent, this is confusing. This is a confusing reference. What are the gag orders? Under New York law, the court's impediment to petitioner's news gathering via gag order wrongfully placed upon a criminal defendant is actionable by petitioners, delete this comma, as a violation of their federal and states' rights to freedom of press. This should be in italics. As detailed below, the gag orders were wrongful. Accordingly, Neerman and Good Logic moved for an order vacating the gag orders imposed on President Donald Trump by Juan Merchan, an acting justice of the New York Supreme Court. Is justice the correct nomenclature? Is that really the correct nomenclature? There's no way that that's correct. I'll mark it. Is justice correct? Or is it judge? Yeah, Judge Merchan. Yeah. Yeah. The New York courts rely on the United States versus Trump in which rulings below. Trump and the gag orders rely heavily on Landmark Communications versus Virginia, Shepard v. Maxwell, and New York Press Association versus Stewart as opening a doorway to silence a defendant to further the fair administration of justice. However, fair administration of justice, as referred to in the cited Supreme Court cases, bears no resemblance to the fair administration of justice as that term is used in Trump or the gag orders. Okay. Little resemblance. When the Supreme Court has used that term to consider infringing a party's First Amendment rights, the fair administration of justice began being protected was the defendant's right to a fair trial under 6th and or 14th Amendments. In those circumstances, the court approved a balancing test to assess that the First Amendment restriction is warranted and then employ strict scrutiny to ensure the employed measure was both compelling need and as narrowly tailored as possible. The high yardstick of strict scrutiny for I'll say any, I'll delete the word sanctioning, any First Amendment limitation applies to a restriction of any nature. The bar is raised even higher when assessing the legality of the First Amendment infringement in the form of a gag order. That relates to core political speech. Yeah. Unlike other First Amendment restrictions, the court has stated you think he may be right with the wording of justice? Well, I'll mark it. I'll let him figure it out. He'll know the New York system better than me. But it seems odd to refer to a member of a trial court as justice. So I was like, that seems odd. So I'll mark it and let him figure it out. Read in context with each other, the Supreme Court decisions create a clear framework for assessing the constitutionality of a gag order. The court starts with a heavy presumption that a gag order is not I'll just say there is, rather. There is a heavy presumption the gag order is not constitutional. However, sometimes the manifestation of First Amendment rights by Party A is so thoroughly intrusive on the constitutional rights to a fair trial of Party B that the fair administration of justice warrants a balancing test to assess where the court must dial back Party A's First Amendment rights. I'll just delete the second half of that sentence completely. I'm well aware that the trial court in New York is called the Supreme Court. I am well aware of that. Otherwise, I wouldn't be making the point in the first place. I'm well aware. So, yes, I'm well aware of that. In United States versus Quattrone, the court dealt with a restriction on prior speech in the form of limiting news coverage. In that case, sitting for the Second Circuit, Justice Sotomayor wrote, well, she's presumably judge. Was Justice Sotomayor on the Second Circuit? Let's see. Yeah, so it would be judge, not justice. Then Judge Sotomayor wrote, in cases whereas here a trial court seeks to restrict news coverage in order to ensure a fair trial, the court must consider whether the nature and extent of news coverage in question would impair the defendant's right to a fair trial, whether measures other than prior restraint on publication exist to mitigate the effects of unrestricted publicity, and the likely effect of prior restraint to prevent the threat and danger. Okay. The backbone to fair administration of justice that empowers it to potentially justify the court intruding. Wow. That I don't like the way that is phrased at all. Let's try this instead. I'm going to rewrite this completely. The foundation of the fair administration of justice on which the court could justify, on which the court can justify encroaching on the party's First Amendment rights, is defendant's constitutionally protected right to a fair trial. Without that foundation, there's no basis for conducting the balancing test in the first place. It's better. The foundation of, on which justify can justify. Yeah, I think that's better. Recognizing that fair administration of justice can only be used as a shield for a defendant and never a sword against him has been the law of the land arguably since 1789, but more formally for no fewer than 35 years. As the Sixth Circuit held in United States versus Ford, it is true that permitting an indicted defendant like Ford to defend himself publicly may result in an overall publicity that someone more favorable to the defendant than would occur were all the parties silence. This does not result in an unfair trial of the government, however. It is the individual defendant to whom the Sixth Amendment guarantees a fair trial. It is the public to whom the First Amendment guarantees reasonable access to criminal proceedings. As to individuals, not governments, to whom the First Amendment interests attach. To the extent that publicity is a disadvantage for the government must tolerate it. The government is our servant, not our masters. Kick ass. I like that. That's very good. Delete that space, though. Thank you for the $10. Appreciate it, Matthew. It's very kind of you. Fair administration of justice as used in Trump. Which Trump? Did you just... All right. You did define it above. Okay. All right, fine. Fair administration of justice is used in Trump, and the underlying as used in Trump and in the underlying case, however, had no aim of protecting anyone's constitutional rights. Protecting, let's strike this. Protecting the defendants protecting a criminal defendant's constitutional rights. which is manifestly obvious as the defendant vociferously. Thank you for the super chats, or thank you for the gift memberships, Alan Parker. Objected to its entry. Vociferously. As used in Trump and the New York gag orders, fair administration of justice references either the court or the state's interests. References not the rights of the defendant as established in the case law, but rather relates to the unknown to case law unknown in the case law let's say the government's interest, say the government's quote unquote rights a fair trial. Related to, I don't even like the way I wrote that. Related to, say, the government's right to a fair trial, which is not protected by the Sixth Amendment. Thank you, Othimer, for the gift memberships. That's always appreciated. We do appreciate everyone who supports the channel. Thank you for 50 gift memberships. That's extensively appreciated. Thank you. As used in Trump and the New York gag orders, fair administration of justice references not the rights of the defendant as established defendant, which are protected by the Constitution, but rather appear to attempt to invoke the government's right to a fair trial, which is not protected by the Sixth Amendment. That's better. This new labeling, rebranding, of the fair administration of justice is wholly inconsistent with the perspective of the Sixth Circuit that fair administration of justice is rooted in constitutional rights and exists solely to protect the defendant. That flows better. Trump and New York's gags orders use of fair administration of justice as a sword to slash defendants' First Amendment rights. Create a new circuit split that merits the court's attention. Okay. We don't need the word your. Applicant respectfully urges the court to reject this new relabeling. Reject this Relabeling is too soft. Reject this corruption, distortion of the concept of fair administration of justice because it is as dangerous as it is novel. It was unprecedented, just it's unprecedented will be fine. It was too passive for my taste. It's unprecedented for this court to justify a gag order against a criminal defendant based upon a purported concern defendant may foment mass hysteria or criminal actions by unnamed, unknown, Oxford comma, until we die, and unaffiliated persons toward trial participants. Objects after vociferously. Fair administration was used to trump an underlying case, however, has no aim of protecting criminal defendants' constitutional rights, which is manifestly obvious as defendant vociferously objects to its entry. You're right. It should be plural. In this case, the court never established a causal link between the defendant's speech and purported harm, never asserted whether the harm from the restricted speech would be remediated via the gag orders. Nice. And never explored less violative means of remediating the potential harms. At best, Judge Merchant employed a fatally flawed application of Nebraska Press Association. Worse yet, and far more damaging to the American jurisprudence, it bespeaks of a dangerous trend towards violating a criminal defendant's most fundamental rights for the purpose of making prosecution. I say making the prosecution more convenient for the government. I like that very much. I like that. That's good. I like what he wrote. The court should note that the New York trial was and remains of the highest newsworthiness. And political import. You don't bespeak of. It bespeaks of a dangerous trend versus it bespeaks a dangerous trend. Well, they both sound okay to my ear. So it bespeaks of a dangerous trend versus it bespeaks a dangerous trend. Yeah, they both sound okay to my ear. So I'll leave it. Yeah, they both sound okay to me. Thus, petitioners' First Amendment rights of freedom of press, President Trump's First Amendment right to speak, and President Trump's 6th and 14th Amendment rights to a fair trial were trampled by the gag orders. The gravity of these matters in settling a circuit split and properly interpreting First Amendment rights would merit the court's attention if the unconstitutional gag orders affected an unknown American in a relatively unknown town. Given the national impact of the case at bar, its magnitude only provides further justification for the court's immediate intervention. I like that. Yeah, you're going to have to he's going to have to put some sort of quick hit description of what the gag order is higher up. He can't just say the gag order. He's got to have some antecedent. He's got to say something like gag orders that limited. He's got to have at least a sentence that establishes what they are. And then he can talk about it in more depth later. That's fine. On April the 4th of 2023, a grand jury in New York County, New York, indicted President Trump on 34 counts of allegedly falsifying business records in the first degree related to an alleged illegal scheme to influence the 2016 presidential election. On February 24th of 2024, the people moved for a gag order. I'd say the government, not the people. Because, you know. The government moved for a gag order, which was consistent with the D.C. Circuit's decision in Trump. On March 26, 2024, Judge Merchant entered a gag order, which did not prescribe President Trump from commenting on family members' meetings of the judge to prosecutors. After President Trump exercised his First and 14th Amendment rights to speak on certain subjects, on April the 1st of 2024, Judge Merchant entered the gag order which specifically prescribed such commentary by President Trump. I'll say preliminary gag order. Neerman is the sole owner of Good Logic LLC. He began podcasting on the YouTube channel called Good Logic, and formed the limited liability company in September 2022, after which he began operating his podcast for the corporate entity's benefit. Mr. Neerman is an official member of the New York Press. How? In what sense? Clarify. I mean, is there like an official, how do you become an official member of the New York Press? How does one do that? He has a badge. Well, okay, but still, like, he's registered. I mean, he needs to tell the court that. He doesn't need to tell he needs to tell the court that. Like, what does that mean? What does it mean to be an official member of the New York Press? What does that mean? Yeah, what does that mean? I don't know what that means. You guys shouldn't be answering this question. The problem is that the brief doesn't answer the question. All right. So whatever the answer is, it should be in the brief. It's like, I don't know what that means. Good Logic and Neerman filed the petition and show cause, or filed their petition and an order to show cause in the appellate division, the court of first instance in this matter, seeking an injunction against Judge Merchant enforcing the gag order and its predecessor. Okay. Good Logic and Neerman argued that the gag orders violate petitioners' freedom of press rights the moment they were entered. Okay. More specifically, Good Logic press inquiries to President Trump about Judge Merchant's relatives could not receive a response. And Good Logic was deprived an interview of President Trump for such reason as well. Okay. Like, were you specifically told this? Like, more of the point. How do you know this? Were you specifically told this? If so, please provide the basis here. The appellate division denied the order to show cause and dismissed the petition. Appeal was taken as a matter of right, based on the allegations that the gag order also violated New York's broader equivalent of the First Amendment. The Court of Appeals dismissed the appeal on September 12, 2024. Okay. A stay pending appeal requires a showing of 4 well-settled factors. This should sound familiar to anyone who's watched this channel for any length of time. You will see these same 4 factors over and over and over again. They'll be phrased differently by different courts, but you'll hear them all the time. So this should sound familiar. Whether the stay applicant has made a strong showing, it's just whether the applicant really. Where the applicant has made a strong showing, he's likely to succeed on the merits. Where the applicant will be irreparably injured absent a stay. Whether issuance of the stay will substantially injure the other party's interest in the proceedings, and where the public interest lies. Is it really where the stay applicant has made a strong showing? Is that really in the original? If it is, then I'll take up my notation. Here, such factors weigh decisively in the favor of the stay. Regarding the merits, an injunction is an extraordinary remedy and may be awarded only upon a clear showing that the plaintiff deserves it. Okay. Good logic meets such difficult standards herein because the court below failed to scrutinize the First Amendment protections afforded to good logic and Neerman as members of the press. And further undertook no examination of the conflicting circuit holdings of Trump and Ford, choosing to ignore the core substantive holdings of Ford altogether, thus violating the core First, Sixth, and 14th Amendment principles. The Supreme Court's default position, the court misanalyzed and misinterpreted Supreme Court precedent and invented a novel legal basis that inverts those very precedents. The Supreme Court's default position is that a gag order carries a heavy presumption of unconstitutionality. In United States versus Quattrone, this should be, again, then Judge, not Justice, then Judge Sotomayor wrote, turning to the merits, we discussed the first doctrine of prior restraints. A prior restraint on speech is a law. Also, this doesn't make sense as a follow-on. Like, you need to have a citation to a Supreme Court case. Like, if you say the Supreme Court's default position, you need to follow that with a Supreme Court citation. Then you can follow it with the Second Circuit, but you really shouldn't, like, jump immediately to, okay. If you are going to lead by saying this is the Supreme Court's default position, the next citation really should be to a U.S. Supreme Court case. Right? I mean, the U.S. Supreme Court's position is completely clear. One time the Second Circuit wrote this. Okay. And then you can follow it with the Second Circuit decision. Then you can follow it with the Second Circuit decision to rub it in Sotomayor's face. But you can't, you gotta take the step, man. Judge Sotomayor wrote, turning to the merits, we discuss first the doctrine of prior restraints. A prior restraint on speech is a law, regulation, or judicial order that suppresses speech. Who gives a fuck about an Oxford comma? Or judicial order that suppresses speech. I need to have a button on my soundboard for who gives a fuck about an Oxford comma that I can push. That's what I need on my soundboard. I need a who gives a fuck about an Oxford comma button. Will one of you guys do me a favor and create a sound clip that is just them literally saying who gives a fuck about an Oxford comma and send it to my email so that I can put it on my soundboard because I need it in my life. Thank you for helping. Where's one of my moderators? What are they doing? Put them to work. Or provides for suppression at the discretion of government officials on the basis of speech's content in advance of actual expression. Okay. Well, Tony, it sounds like you got some work for you. I need a sound clip, man. It's long been established that such restraints constitutes the most serious and least tolerable infringement of freedom of speech and press. Indeed, the Supreme Court has described the elimination of prior restraint as the chief purpose of the First Amendment. Oxford comma, always and forever. You better believe it, baby. 100%. Any position on prior restraint therefore bears a heavy presumption against constitutional validity. Fair enough. This court has never employed the concept of fair administration of justice as a basis to necessitate a balancing test to restrict free speech unless the objective was to preserve a third party's constitutional rights. Are you sure? Don't you mean the defendant's constitutional rights? Oh, no, it's from a song, Tony. There's a song called Oxford comma. It's from the song. Who gives a fuck about an Oxford comma? I need the sound clip from the song. Yeah. No, I'm not looking. I need this. I need the sound clip from the song. Yeah. Is Tony uncultured? He doesn't know this? That was the precise observation of the Supreme Court in the very case cited by Judge Merchant in the gag orders. Are you a bad person if you prefer not to use the Oxford comma? Yes. You're a bad person. You should be shamed. Shame. 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 That was the precise observation of the Supreme Court in the very case cited by Judge Merchant in the gag orders. The song may be copyright protected. I'm using literally less than a second of audio, so I think it'll be fine. In assessing whether there's sufficient clear and present danger that exists to warrant prior restraint of free speech, the Supreme Court wrote, in a series of cases raising questions of whether the contempt power could be used to punish out-of-court comments concerning pending cases or grand jury investigations, this court has constantly rejected the argument that such commentary constituted clear and present danger to the administration of justice. Nice. What emerges from those cases is the working principle: the substantive evil must be extremely serious, and the degree of imminence extremely high before utterances can be punished, and that requires a solidity of evidence. It's necessary to make the requisite showing of imminence. The danger must not be remote or even probable; it must be immediate peril. In exceedingly rare circumstances, when driven by the very powerful interests or preserving constitutional right, fair administration of justice may have the force to effect otherwise impenetrable First Amendment rights. To attain sufficient power to infringe on a fundamental right, administration of justice must play servant to a powerful master. That master must be the compelling need of protecting a competing constitutional right. You have that song on vinyl? Nice. Shepard v. Maxwell is express that justice dictated, providing the 14th Amendment. Wow, that is poorly phrased. Shepard v. Maxwell is express that justice dictated, protecting the 14th Amendment constitutional rights of the defendant. That just, I need to rewrite that sentence completely. That's it. Yeah. That sentence needs to go, that sentence needs to go outside and be shot. Let's fix that. Shepard v. Maxwell, 1966, provided that First Amendment rights of the press can be restrained, but only for the specific benefit of the criminal defendant based on the right to a fair trial implicit in the Sixth Amendment. Sorry for the snort thing. I've been having issues with my nose for such a long time, man. It's a problem, but the court recognized that the unchecked First Amendment tidal waves, immediate intervention in the Shepard trial, devastated the defendant's ability to have a fair trial, and that was a violation of the 14th Amendment due process rights. Neti pot? No, man, that sounds Something, man. Because the court was concerned with preservation of defendants' constitutional rights to a fair trial, fair administration of justice warranted restriction of First Amendment rights. Let's say tempering rather than restriction. Neti pot feels weird, but it does clear things out. Okay. I'll get myself a neti pot. In Nebraska Press Association versus Stewart, court made evident the only time a court should even consider overcoming the heavy presumption of constitutional invalidity that attaches to a gag order is when there are competing constitutional rights. Okay. Neti pot or swim in the ocean? All right, where do I buy a neti pot? Using salt water? Oh, it just uses saline? Well, why can't I just use saline spray? I've got saline spray. Just got myself simple saline. Extra strength. Drug-free saline. I could use that. Hold on. I have now shot salt water up my nose. In Nebraska, likely story. Yeah. Excuse me, I need to use the bathroom real fast. Oh, man. Anyways, where was I? The court made evident the only time the court should even consider overcoming the heavy presumption of constitutional invalidity that attaches to gag orders where there's competing constitutional rights. The authors of the Bill of Rights did not undertake to assign priorities as between First Amendment and Sixth Amendment. Let's see if I can do my best Nick Rekieta post-nose impression. Oh, I don't even know if I can do this properly. This guys, it's just I don't know about this brief. It's just not really. Yeah. I don't know, man. It just doesn't really flow that well. It says Nebraska Press Association. What is that all about? Does that work? Is that funny? No? Okay. Well, I'll work on it. In Nebraska Association versus Stewart, the court made evident the only time a court should even consider overcoming the heavy presumption of constitutional validity that attaches to a gag order is where there's competing constitutional rights. The author of the Bill of Rights did not undertake to assign priorities as between First Amendment and Sixth Amendment rights, ranking one as superior to the other. Yet it's nonetheless clear that the barriers to prior restraint remain high unless we are to abandon what the court has said for nearly a quarter of our natural existence and apply throughout all of it. I'll get myself a nutty pot. Where do you send me an audio clip? You can just post it right to my Discord. That'll be helpful. Just dump it right on my Discord. It should be fine. Or email will also work at kurt@uncivillawllc.com. In every Supreme Court decision cited by the gag orders, there were competing constitutional interests. Relating specifically to the rights of the defendant. If so, say this. Generally, we see a conflict between freedom of speech, press versus individual due process rights. When girded by due process interests, First Amendment rights will still prevail over interests of justice unless the danger is both certain and imminent. In the case of Barr, we have the highly unusual situation where both constitutional interests are on the safe side of the equation favoring the defendant and demanding jointly and severably restriction of any gag order. I think I'm going to delete the jointly and severally part. I'll get myself a neti pot. I'll go to the drugstore and get myself a neti pot and some distilled water. Any reading of Landmark, Shepherd, and or Nebraska Association that concludes a court is empowered to issue a gag order in the face of both the First and 14th Amendments and against the express wishes of the defendant whose interests I just say it's fanciful. None of the cases cited by Judge Merchant in entertaining the gag orders concerned an order intended to gag the criminal defendant himself. Historically, the law has taken extra precautions to ensure that all activities surrounding a criminal trial are taken into account. First and foremost, the criminal defendant's right to a fair trial under the 6th and 14th Amendments, which include his or her right to speak out about the charges and circumstances surrounding the trial. Moreover, some of the cases relied on by Judge Merchant were not even criminal cases. Recognizing the state bears the burden of proof, such basis for imposing a gag order, which was affirmed by the courts below, fails to meet this burden. Fine. You went from a neti pot to a navage. Navage. What's a navage? I see. It's a salt pod thing. Interesting. Let's see. It's a big looking thing, man. Wow, it looks like one hell of a device, man. I think the All Writs Act should be mentioned. No. And justice is correct for the New York Supreme Court. Okay. Pressure washer. Pressure wash my nasal cavity. Recognizing the state bears its burden of proof, such basis for imposing the gag order, which is affirmed by the courts below, fails to meet the burden. For instance, Seattle Time versus Reinhart was a civil case where this court precluded media companies from disseminating potentially harmful materials about the civil plaintiff that had been developed during the discovery. The holding was limited to discovery from the civil case. Yet Judge Merchant relied on it in entering the gag order. Shepard v. Maxwell limited speech because its form of expression was damaging the criminal defendant's ability to obtain a fair trial and thereby violate defendant's 14th Amendment fair trial rights. Thus, Shepard's holding contradicts Judge Merchant's determination to impose the gag order on President Trump. The Logitech MX Creative Console. What is a Logitech MX Creative Console? What the hell is this? Advanced dial pad and keypad. I don't need that in my life. Yeah, no. Yeah, no. I don't see that. Yeah, I don't see the, no, that's not for me. No, that's okay. That's not for me. All right, let's see. Okay, well. Email sent? I didn't get your email. No email for Uncivil. Yeah. Oh, wait. There it is. There it is. It got caught in my spam folder. Nice. Love it. It's definitely going in a folder somewhere. Hold on. Now let's see. Hold on. How do I do this? I can do this. Hold on. Let's see. Stream Deck. All right. And if I press this and I say do this, then, and I press this button. Yeah. Love it. Love it. I have a button now. I have a button now. Button make me happy. Push button. Push the button. Push button. All right. Shepard v. Maxwell limited speech because of its form of expression was damaging criminal defendant's ability to obtain a fair trial and thereby violate defendant's 14th Amendment fair trial rights. Thus, Shepard's holding contradicts Judge Merchant's determination to impose a gag order on President Trump. Notably, in Shepard, the court quoted Chambliss v. Florida. When writing, the court has insisted no one be punished for a crime without a charge fairly made and fairly tried in a public tribunal, free of prejudice, passion, excitement, and tyrannical power. In other words, this court's concern with restricting speech at trial is not related to a criminal defendant's speech so that the prosecution is deprived of a smooth trial, which is not subject to scrutiny, but is rather concerned with the defendant being deprived of his trial by preventing the criminal defendant from being silenced. Finally, Judge Merchant relied on Gentile, which concerned the standard for placing restrictions on attorney speech relating to pretrial publicity. My sinuses do feel clearer. My sinuses do feel clearer. So the salt solution stuff does seem to actually work a little bit. So my sinuses do feel clearer. So hey, more salt water for Uncivil. Again, the question of whether a criminal defendant could be gagged during trial is not an issue. Rather, the crux of the issue was whether a standard that the attorney's speech present a substantial likelihood of material prejudice, as opposed to the long-held standard that such speech present a clear and present danger, violate an attorney's First Amendment protection. This court held that the standard itself does not cause a violation of the attorney's First Amendment protection, but rather the state has not demonstrated that the attorney's speech, which was subject to disciplinary hearing at the conclusion of trial, had in fact demonstrated a substantial likelihood of material prejudice. Gentile only serves to underscore that even if New York were permitted to engage in a balancing test in the case at bar, it only failed to do so in accordance with Nebraska. Nice. I should just try to remember to use it before I go on stream. I should just try to remember to use it like 5 or 10 minutes before I go on stream, and then like maybe I won't be as distracting on stream. If the court had not erred in it by engaging in the balancing test, its utter failure to comport with Nebraska warrants an immediate stay of the gag orders. As the Second Circuit held in Quattrone, where the category speech otherwise receives First Amendment protection, however, courts subject prior restraint on speech or publications to exacting review. In cases where, as here, a trial court seeks to restrict news coverage in order to ensure a fair trial, the court must consider whether the nature and extent of news coverage in question would impair the defendant's right to a fair trial, whether measures other than prior restraint on publication exist to mitigate the effects of unrestricted publicity, and the likely efficacy of prior restraint to prevent the threat and danger. The reviewing court must examine closely both the record and precise terms of the restrictive order, application of the Nebraska press test to the instant case, demonstrate the district court's order violated the First Amendment rights. The first test referenced in Quattrone is consistent with Gentile, which holds that regardless of whether a serious and imminent threat or a substantial likelihood of material prejudice standard is applied, each requires assessment of proximity and degree of harm. Judge Merchant offered no evidence that President Trump's words have proximity to any real-time harm of any degree. I don't like the way that that's phrased. Let me see. Let me try rewriting that. Yeah, I'll just keep it simple. Indeed, in issuing the gag orders, comma, Judge Merchan never verified that Trump's statement had any causal link whatsoever to any, rather than the harm, I'll say, rather whatsoever to any harm complained of. I've recently fallen down the rabbit hole of fitness influencer YouTube for some reason. So I've recently been watching a lot of videos from fitness influencer YouTube. It's pretty interesting. So maybe I'll be a fitness influencer too. That'll be exciting. I don't want to cite the All Writs Act. It's not my yeah, I don't want to cite the All Writs Act. Citing the All Writs Act is a desperate move. I don't want to sign it. The record is further devoid of any indication that Judge Merchan spent any time considering the viability of less restrictive measures. The court could have considered protective custody for the witnesses, anonymity of the jury, and a host of other remedies before jumping into a prior restraint of free speech. All applications are All Writ Act? No, they're not. All Writ Act is like when you don't have anything else. There's separate authority for this. No. Finally, the court completely disregarded its obligations to verify the probable effect of the gag orders. The topic discussed by Trump that purportedly incited harm, although the court never established it did, were and are being discussed by countless other sources every day. The only investigation Judge Merchan engaged in was prosecutorial claims that during the 1 year prior to trial, Trump increased his verbal attacks on various trial participants, and that trial participants purportedly experienced an increase in verbal hostility from unrelated third parties during that year. The court never investigated whether the hostilities displayed any temporal or content relation to Trump's statements, or whether the hostility continued even during periods where Trump was silent about trial participants. Simply put, given the information is being given that the information given that The same issues that were routinely discussed about on every political medium imaginable. The likely efficacy seems close to nil. Were the purported focus of the gag orders continues to be routinely discussed on every political medium imaginable. The likely efficacy of the gag orders seems close to nil. No, he won't lose his law license. Why would you even say that? That doesn't make any sense. Accordingly, even if Nebraska's balancing test were appropriate and not prohibited by Supreme Court precedent, court's failure to properly implement Nebraska warrants a likelihood of petitioner's success and an immediate stay. If petitioner's application for relief is denied, they will suffer irreparable harm. The Supreme Court said in Elrod v. Burns, the loss of the First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. Currently, the trial court has concluded the jury has issued its verdict. While the court never conducted a proper investigation to establish a causal link between Trump's speech and purported harm, if there was such harm, it certainly passed with the conclusion of Trump. Moreover, it's inconceivable that Trump speaking about the trial and or its participants will have any additional impact beyond the discussions being conducted and or generated by countless other members of the media. Okay. Has it... I think I'd move this sentence, move it around, and move it over here. Seems inarguable to claim the issuance of the stay does anything but serve the public interest. Based on the foregoing, all four factors weigh considerably in favor of the stay. Okay. I need more water. And I need to use the restroom. Be right back. Okay. Got my water. Peach tea, by the way. It's Crystal Light. The peach green tea. I like it very much. It's the one I always drink. I like the peach green tea. It's peachy and green tea-y. It's nice. I'm trying a new work. Just to take a break. I need a mental break for just a second, so we'll just talk about some other stuff while I'm thinking. I'm trying a new fitness app called Future, which has virtual coaches, so an actual human being on the other end. It's like $200 a month, but the first month is $100. It's like, okay, I'll give it a shot, see how that I like that. So I'm supposed to start on that on Monday. And then there's also another app that I was looking at called Caliber. And it has something very similar, like $200 a month, but $100 for the first month. So it's like, well, after the month with Future, I might try the Caliber app and see if I like either one of those better. To try to, get to the gym better and see what I can do in terms of fitness and stuff. So, yeah. All that good stuff. I don't need an app. I don't need an app for Uncivil. I'm not sure what such an app would do. So, I don't know. I don't have any real desire to write an app for myself. But yeah. So, I'll let you know how that turns out on Monday. To track my workouts? Oh, I have no interest in that whatsoever. There's already so many apps out there that are used for tracking workouts. There's no need for there to be another app. I have no desire to create another app. I don't want another app. It's like, no, I don't want you to create. I don't want an app. I just use one of the many apps that already exist. Just find the best one. It's like, I don't need you to create me an app. There's 8,000 workout apps. That's fine. How do I know what to lift? Well, up until this point, I've been using an AI app. I've been using Fitbod to recommend what workouts to do. So I've been using AI to recommend my workouts when I go. So that's what I've been using up till now. And then I'm going to try a human being. So, yeah. We'll see. I don't need an app. I really don't. I don't want to write an app. I don't want to manage an app. I don't need that frustration in my life. Splitting the circuits on the issue of gagging a criminal defendant so his words may not hamper the conduct of a criminal trial should be resolved in favor of freedom of speech. As noted above, circuit courts are split regarding whether it's appropriate to gag a criminal defendant so his or her words do not potentially prejudice a trial due to adverse publicity. And assessing whether one or the other circuit court correctly analyzed the question, we are reminded that the ultimate protection of life, liberty, and property in criminal trials belong to the accused. As the prosecution bears the burden of proof, the accused is entitled to all constitutional protections, including the right to publicly declare his or her innocence. Does he have standing? It's actually a reasonable question. It's actually a reasonable question whether he has standing or not. Yeah. Thus, the question becomes whether under what circumstances the accused may be gagged from speaking out about the issues directly affect his or her guilt or innocence. Good logic asserts that the Sixth Amendment analysis in forward is keeping with the nation's history of protecting the rights of the criminal defendant above all else. Where's Joe? Well, it's Saturday. Where do you think he is? Ugh. Is Joe on vacation? It's Saturday. Joe is Jewish. Okay. Oh, Lord. Good logic asserts the Sixth Amendment Circuit announced in Ford is keep with the nation's history of protecting the rights of the criminal defendant above all else. Contrarily, who else would have standing? I mean, Trump has standing. Contrarily, the DC Circuit in Trump broke new ground in unprecedented evisceration of long-held constitutional protections for the accused and the press. Courts below upheld Judge Merchan's gag order on such basis, which cannot withstand constitutional scrutiny. In Ford, the Sixth Circuit was confronted with a lower court gags order imposed on Congressman Harold Ford, who had been charged with mail and bank fraud. The gag order prohibited Congressman Ford from making any extrajudicial statements that a reasonable person would expect to be disseminated by means of public communication, including any opinion of or discussion of the evidence and facts in the investigation or case, any statement about prosecuting attorney, any statement about alleged motive the government may have had in filing this indictment, or any statement relates to any opinion of the merits of the case. The Sixth Circuit noted that, as the accused, Congressman Ford had a First Amendment right to reply publicly to the prosecutor's charges, and the public has the right to hear the reply because of ongoing concern for the integrity of the criminal justice system and the need to hear from those most directly affected by it. Nice. The Sixth Circuit further wrote that once the parties and the witnesses in a criminal case are outside the courtroom, they have the full prerogative of any private citizen to question, criticize, or condemn the actions of the government, even though they may be swept in the process at the time. Fair. The court continued that although Congressman Ford's commentary may bring more publicity to his case, that is favorable to him that would have occurred if he was silenced. This does not result in an unfair trial of the government. This is a great case for Joe. Indeed, the court noted that it's the public to whom the First Amendment guarantees reasonable access to criminal proceedings. Further, the court asserted it's individuals, not the government, to whom First Amendment interests attach. To the extent that publicity is a disadvantage for the government must tolerate it. The government is our servant, not our master. Thus, applying the clear and present danger standard, the Sixth Circuit determined the subject gag order failed to comply with the First Amendment. To so comport with the First Amendment, the court noted the gag order must be based on the question of whether such speech presents a serious and imminent threat of a specific nature, the remedy to which can be narrowly tailored in the injunctive order. To the contrary, in Trump, on which the courts below relied on upholding the gag orders and faced a good log's challenge. Okay. The DC Circuit issued the clear and present danger standard and examined the issue as being whether any compelling interest justifies an appropriate limited speech restriction. The DC Circuit cited Landmark Communications versus Virginia, which reaches its conclusion that a gag order was merited against Trump. I want to go to the gym today and sit in the sauna for a while. After this, I'm gonna go to the song. I'm gonna go to the gym. After this, I'm gonna go to the gym. I'm gonna do a light workout. Probably just do some lat pull downs and some easy bar curls and maybe some row. Maybe some tricep push down. And then I'm going to go sit in the sauna for a while. And I might alternate between the steam and the sauna because they have both. That sounds good. I like this plan. This is a good plan. I like this plan. Yeah, sauna at home would be a dream. I know. I was telling my mom today, like I think she should get a sauna. I think she should get an infrared one, you know? That way I can visit and I can just use the infrared sauna. I think that'd be good. But yeah. You've got a dry finish barrel sauna. That's kind of old school, but I respect. You've got a dry barrel sauna. That's kind of old school, man. That's old school. Don't go infrared, go dry finish with a heater. I don't know, man. I think the infrared might be superior. I mean, there's infinite debates on this issue online, as I'm sure you well know, but the infrared might be superior. Deeper penetration and so forth and so on. Barrel sauna is the way to go, you think? All right, maybe. Put a dehumidifier inside that son of a bitch and call it a day, man. It's basically a glorified microwave. Well, not really, no. I mean, not to put too fine a point on it, but you do understand that microwave and infrared are two different parts of the spectrum, right? So there's that. But okay. That's a little bit like saying a light bulb is a glorified microwave. Because a light bulb also works on this electromagnetic spectrum. Ooh. DC circuit, that's also, the radio stations are also microwaves. Everything's microwaves. Everything is awesome. If you have a sauna at home, please tell me more about your sauna. I will live vicariously through you for the moment. Please tell me more about your sauna and your enjoyment of your sauna. In Upper Peninsula, you give Finland a run for money for saunas? Neat. Costco purchase $8,000? Yep. The DC Circuit cited landmark communication when reaching its conclusion that well, I don't necessarily have a sauna, but I could get myself a space heater and a closet. And that'd be about the same, right? Just get myself a space heater and a space heater in a closet, call it a day. The DC Circuit cited Landmark Communications versus Virginia when reaching its conclusion that a gag order was merited against President Trump. However, the DC Circuit misread Landmark Communication and, in doing so, turned off. I live in Texas. Isn't that a sauna? You do have a point. Based on unprecedented standard to use against a criminal defendant in a criminal trial. Landmark Communications concerned the press's First Amendment right to report on alleged misconduct of a judge. This court noted therein that on the question of whether the contempt power could be used to punish out-of-court comments concerning pending cases or grand jury investigations, this court has consistently rejected the argument that such commentary constitutes a clear and present administration of justice. I'm going to put that in bold. Consistently rejected, emphasis added. Reviewing prior cases, this court noted that if the threat of contempt is to be employed, what emerges from these cases is the working principle: the substantive evil must be extremely serious and the degree of imminence extremely high before utterances can be punished, and that a solidity of evidence is necessary to make the requisite showing of imminence. This court continued that the danger must not be remote or even probable. It must immediately imperil. Despite its reliance on landmark communications, the D.C. Circuit did not apply the clear and present danger standard. Rather, it looked to Nebraska Press Association versus Stewart, and also misapplied that case to determine that a gag order was permissible by employing a standard that Trump's speech posed a significant imminent threat to the fair and orderly adjudication of the criminal proceeding against him. However, in leading to such a conclusion, the D.C. Circuit misstated the central premise of Stewart by asserting that its holding constituted an exhortation to courts to take remedial measures that will prevent prejudice by the accused and other persons coming under the jurisdiction of the court. I don't like this at all. Remedial measures that will prevent... I'm just going to take it out of the quote marks and delete these like this stuff. And other persons coming under the jurisdiction of the court. What the D.C. Circuit failed to recognize is that the Stewart Court also applied the clear and present danger standard, and the court's overarching concern was to preserve the defendant's right to a fair trial by the impanelment of an impartial jury. As noted above, shy of perhaps a criminal defendant's words presenting a clear and present danger of damaging the integrity of the jury pool, Stewart presents no foundation for a general gag order against a criminal defendant for the purpose of easing the burden of the trial on the prosecution and the presiding judges, as is the case here. Judge Merchant similarly failed to apply the clear and present danger standard, and also failed to analyze the cases on which he relied in issuing the gag orders from the perspective of President Trump's right to a fair trial, including his First Amendment rights to speak about Judge Merchant's conflict of interest, which should have necessitated his recusal. Judge Merchant did cite forward in the decision to enter the gag order. But failed to cite its central holding that criminal defendants are entitled to the highest First Amendment protection since it's their liberty which is at stake. By holding that the prosecution and Judge Merchant himself were to be insulated from legitimate criticism of their family members by President Trump, which determination was upheld by the court. Delete this part here. An unsubstantial an unsustainable standard of review was employed and employed. This should have a period. This relieved the state of providing the clear and present dangers that the defendant's speech allegedly presented to the trial. Approving. Okay. Such standard is likely to be reversed on the merits hearing. Okay. I love you, chat. I love you, chat. Thank you for being here with me. Thank you for spending a little time with me. You're awesome. Oxford comma for the win. Who gives a fuck about an Oxford comma? Yeah. We need more sounds for the soundboard. That's what we need, though. Tony, we need Tony. You can help supervise that. We need more sounds for the soundboard that we can like curate for Uncivil. Good sounds for the soundboard, and that'd be good. I got a new back for my chair. What kind of sounds? I don't know. Whatever kind of sounds would be good for an Uncivil Law soundboard. I mean, at the risk of a tautology, it's like, I don't know, but it'd just be cool to have like additional sound cues that would be fun to use. So this channel could be a little bit more like, what's his name? Lead attorney, who's got his soundboard game down pretty well. Also, we need like sounds for, we could also use sounds that would be good for us. Here's one we could do that would be good for different dollar amounts. So when we get different dollar amounts, we have sounds, because like Runkle does that and Good Logic does that. And that's a good idea. So we could have sounds for like 10, 20, 50, $100. That'd be good. But they should be like, you know, distinct so that it makes sense that they're on my channel. So that'd be good. We should have a sound for a $10 donation, a sound for a $20 donation, a sound for a $50 donation, and a sound for a $100 donation. I think that'd be good. And that way, you know, that'd be fun to have. So that'd be fun. So there's something we could do, and just whatever other sounds might be fun to just, you know, spice things up and make things more interesting and be more uncivil. Daryl Brooks, if you want to cut up some of Daryl Brooks' stuff and make some sound clips out of Daryl Brooks, I think that'd be fun. Yeah, if you want to cut up some of Daryl Brooks stuff and send over those kinds of sounds, that'd be fun. We could have some Daryl Brooks sounds, grounds for the sustained, and whatever else, you know, was in there that would be good. People like wacky sounds. People like wacky sounds. It's hard to be uncivil in chat because we have so many rules. Fair. The law may be uncivil, but it doesn't mean that we have to be, right? If there's any fixed order in our constitutional constellation, it's the principle the government may not interfere with the uninhibited marketplace of ideas. Nice. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Debate on public issues will not be uninhibited if the speaker must run the risk that it'll be proved in court that he spoke out of hatred. And if he did speak out of hatred, utterances honestly believed to contribute to the free exchange of ideas and ascertainment of the truth. Nice. Moreover, in the case of charges against a popular political figure, it may be almost impossible to show freedom from ill will or selfish political motives. Fair. Will the 100K order impact the case? No. It will not. The First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. In a republic where the people are sovereign, the ability of citizenry to make informed choices among candidates for office is essential, for the identities of those who are elected will invariably shape the course that we follow as a nation. The candidate, no less than any other person, isn't Buckley v. Vallejo like overruled? Used to do an audio-only podcast. I'll go through your collection of sounds and send some over. Kick ass. I look forward to receiving them. The candidate, no less than any other person, has the First Amendment right to engage in discussion of public issues and vigorously and tirelessly to advocate his own election and the election of other candidates. That discussion is critical to enabling the electorate to intelligently evaluate the candidate's personal qualities and their position on vital public issues before choosing among them on election day. Not fair enough. Similar to general principles of free speech on matters of public concern, the right to a robust, free press is entitled to the highest of constitutional protections. Freedom of press is a fundamental personal right, which is not confined to newspapers and periodicals. It necessarily embraces pamphlets and leaflets. The press, in its historic connotation, comprehends every sort of publication which affords a vehicle of information and opinion. News gathering is not without its First Amendment protections. Without some protection for seeking out the news, freedom of press could be eviscerated. The liberty of the press is indeed essential to the nature of the free state, which consists in laying no previous restraints upon publication. Every free man has undoubtedly the right to lay what sentiments he pleases before the public. To forbid this is to destroy freedom of press. One needs to look no further. My eyes are really hurting right now. Sorry. Sometimes the light gets to me. Sometimes the light gets to me, and today is one of those days. One needs to look no further than the New York Times versus Sullivan to understand the wide berth the First Amendment provides to freedom of the press. Widely known as the Pentagon Papers case, This court rejected efforts by the government to restrain publication of a stolen classified study entitled History of U.S. Decision-Making Process on Vietnam Policy. Any system of prior restraint of expression comes to this court bearing a heavy presumption against its constitutional validity. The government thus carries a heavy burden of showing justification for the imposition of such restraint. It must be recognized that the public interest is much more likely to be kindled by a controversial event of the day than by generalization, however penetrating, of the history or scientist. No suggestion can be found in the Constitution that the freedom there guaranteed for speech and press bears an inverse ratio to the timeliness and importance of the idea-seeking impression. Neat. At the equities warrant a stay. The fact that the gag order protected Judge Merchant from having to face legitimate media inquiries to President Trump about Judge Merchant conflicts of interest merits a stay. Rewrite. Yep. I'll take that rephrasing. Thank you, ChatGPT. Yoink. A stay is justified because the gag order shielded Judge Merchant from legitimate media inquiries to President Trump about the judge's conflict of interest. That makes more sense. Yeah, bend the arms a little. I've been trying to bend the arms a little, but they just... At the outset, in light of extraordinary circumstances of this matter in which a former president and leading presidential candidate have been gagged from discussing individuals whose conflicts appear to require recusal of the judge who wear the gag order, a stay should be granted. The gag order violates numerous bedrock constitutional principles. Yeah. I want to look fabulous with my glasses, you know? I want to look fabulous. Do I look fabulous? They look crooked, man, right? The gag orders prevent petitioner from obtaining newsworthy comment from President Trump about such issues, which appear to potentially place Judge Merchant in direct conflict with his obligations pursuant to stuff. As Judge Merchant's wife works for James, who's James? Who's James? Letitia James. Okay. Letitia James is what is her title exactly? Yeah, she's the Attorney General. That's what I thought. Campaign become Attorney General by, let's lock him up. Yeah, that's better. Judge Merchant's wife is 1 degree away from the person with an interest that may be substantially affected by the criminal trial. E, not I. Okay. If the gag order prevents President Trump from speaking about Judge Merchant's wife, even if the jury has found him guilty. Likewise, Judge Merchant's daughter has made millions of dollars as a publicist for Biden Harris, which may be based significant concerns have been raised as to whether President Trump has been found guilty at a trial presided over by a judge who was conflicted and was obligated to recuse himself because of conflicts caused by his family's members. God, my damn, that light is bright. Holy shit. That light is bright today. Oh, it's Linktree. Linktree is the prompt. That's right. There you go. Linktree is the prompt. That's the one. Significant concerns have been raised to whether President Trump has been found guilty of the trial presided over by a judge who was conflicted and who obligated to recuse himself because of conflicts caused by his family members. Such concerns certainly are newsworthy and directly affect the criminal defendant's right to a fair trial. Thus, the First Amendment right of free press, President Trump's First and 14th Amendment rights to free speech, and the 6th and 14th Amendment rights to a fair trial are all being trampled by the gag order as relate to President Trump being silent about Judge Merchan's wife and daughter. Moreover, the gag order and conviction exist in the midst of a presidential election and could impact the outcome based on President Trump not being able to comment about those criminal facts which the broader public has the right to know, facts about which petitioners have sought and were denied comment by President Trump because of the gag order. It's an interesting idea for trying to gain standing. It's an interesting idea for trying to gain standing, that's for sure. And the screw is like partially. Small bit. I think it's better. All right. The integrity of judicial making of it's not needed. And the integrity of federal elections have both been subjects which were before this court just last term. Judge Mitchell JAG order implicates both and in the wrong way. Judicial system, and in particular criminal justice courts, play a vital part in a democratic state, and the public has a legitimate interest in their operations. Public vigilance serves us well for the knowledge that every criminal trial is subject to contemporaneous review in the form of public opinion as effective restraint on possible abuse of judicial power. Nice. By protecting his family against comment and by a criminal defendant in his court, Judge Merchan also helped to protect himself against significant public scrutiny. Also, helped to protect himself against significant public scrutiny that President Trump would bring to bear on the subject of his irreconcilable conflicts of interest and abuse of judicial power. Further, President Trump was convicted of multiple felonies, numerous felonies, in Judge Merchan's court, all of which may have been tainted by Judge Merchan's conflict of interest. President Trump undeniably has as strong of a media voice as any American who came before him. Delete that sentence. It's not doing anything. Thus, by silencing President Trump from speaking about the conflicts associated with the Judge Merchan's family, significant damage is done to the public knowledge of critical issues that could impact the 2024 presidential election, such that voters stand to be deceived by information about the convictions. Such damage to judicial integrity, which may also be, it's just not even. Might have to switch to different glasses because these ones are like bent a little bit or something. I don't know. These ones are just not like exactly even. They're like a little tilted. For all the above reasons, this court should stay the gag order. Alternatively, this court could construe this application as a petition for writ of certiorari, grant the petition, and set this case for expedited briefing and argument this term on the question whether the gag order was unconstitutional. Particularly with the presidential election just weeks away, that's tight. Although the Supreme Court has moved faster when they really want to. The question of the gag order on President Trump's ability to communicate with the press concerning his conviction should be reviewed without delay, so the public has a full and fair opportunity to hear President Trump's commentary on the issues, so their decisions as to the candidate for they vote will be better informed. Okay. Okay. All right. So I think that will conclude us for today. That will conclude us for now. I'll take another poke at that. Just to take another look at it. But I think we made a bit of progress, improving it. So it's not all bad. Are you feeling the uncivil with the sunglasses? Are we feeling it? Today Uncivil's eyes are definitely having objections. That light today is just like right in my eyes, man. It's just oof. It's rough. All right, I'm going to go ahead and go to the gym because I think they close today at 7. So they're only open for another 2 hours. They close early on the weekend. They're open like 5 days a week, 24 hours, and then on the weekend they're open from like 7 to 7. So I'm going to go ahead and go to the gym and just do something light today. Just, lat pull down, barbell curl, cable row. What else would be good? I'll do some machine fly, and I'll do some delt. I'll do some machine delt. That'll be good. And what else should I throw in there? Maybe I'll do like a tricep pull down or something like that. That'd be good. Yeah. And then I'll just sit in the sauna for some time and refresh my pores. So I think that'll be good. Swimming? Not a swimming kind of guy. No, no, not really. Not really. Also, I'm very self conscious because of my weight. I don't want to do my best you know, Shamu impression. So swimming is not really in the cards for me today, no. Hypothetically, I could get in the hot tub at the gym, but then I might have to take off my shirt, and that's the same problem. Well, I guess I could wear a shirt in the hot tub, although it'd be really kind of weird too. So yeah. All right. I'm gonna go to the gym for a little while and see what happens. I'll talk to you later, Gata.